Good morning. I'm Jinshia, and a warm welcome to everyone for the TDP session of LGRF. Today, our topic is copyright. The session is started by Dr. Lawellman, sir, Assistant Professor, Government Law College, Kozhikode. Uh, I again welcome here all, sir.
Hello, sir. Mute ra. Hello, sir. Good morning. Sir, start ചെയ്യാം നമുക്ക്. Sir, mute ആയെന്ന് തോന്നുന്നു.
നമ്മൾ തുടങ്ങാല്ലേ നേരിട്ട് സ്റ്റാർട്ട് ചെയ്യാം.
Yes, yes.
Okay. So, very good morning to everyone. It's long since we met because of certain other engagements and some festivals in between. Now we are back to our discussion on intellectual property rights. As I'm sure you will remember that the area we were discussing was copyright, which you can see on the screen as well. As it is a long time since we met, I thought I'll just give you a short recap of what we discussed, or we'll just flip through the slides we discussed, the main points. So we had the idea of copyright itself, the very purpose of copyright. We went through all this. Copyright Act 1957 is the law dealing with that. Then this is also an important one because as far as copyright is concerned, there are as many as 6 subject matters which are identified under Section 13 of copyright law. Those are literary work, artistic work, dramatic work, musical work, sound recording, and cinematography. Which means to have copyright, the creative work we created should fit into any of these categories. That's the basic understanding we need to have. And then we had an understanding. We went through. We had a better understanding of different subject matters of copyright, like literary work, then artistic work, then dramatic work, then musical work, sound recording, and cinematography. We went through the definitions of that as well. Then obviously the idea we had to discuss was who is the author, the person, the creator. Creator is at the center of copyright, and we had an idea about the creator as well, and the creator in the case of literary work, people, and other details are on the screen. This is just for the purpose of preparation or memory. Then the duration of copyright, which is unique as far as intellectual property is concerned. So, in contradistinction with any other property, one of the unique features of intellectual property is that intellectual property is of a limited duration. That is a remarkable, notable point. So is the case with copyright as well. In the case of copyright, there are two rules. In the case of published literary, dramatic, musical, and artistic work, as per chapter 5, sections 22 to 29. The duration of copyright is life of the author plus 60 years. We considered one of the best examples we can ever consider in India, and we have an idea about it. And the rule 2 goes like this. It is applicable in case of photographs, cinematography, sound recording, and things like that. And where rule 2 says it is 60 years from the date of publication. That's what copyright law says. Then we went on to some of the basic principles of copyright law, like originality, idea expression, dichotomy, and fixation. So when we went through one of the most important, you can't miss this case. I had this opinion earlier as well, and I still hold this opinion. London University Press Limited versus University Tutorial Press Limited case. It is a very old case, more than 100 years, a centurion case, but still important. It is being quoted often, even by the courts in India, even in 2020. So it is an important case, and it makes you understand almost all the basic concepts of copyright law. So this case also is discussed. It's a mathematics question paper case where originality, literary work, and things like that are discussed. Even fair use is discussed in that. So original expressions are being protected. That's a basic idea. Ideas need not be original. You can have your own expression of an idea which is as old as a case, and that's what they say. So ideas need not be new, but the expression should be. And the quantum of originality, it is the originality of expression that matters. You as an author, I as an author, should have bestow our intellectual labor for the creation of that particular work. That's a basic idea. That's what we call as originality. You are just extending the gray matter of your brain. So quantum of originality required is not that very high. That is what is being indicated and conveyed in the case London University Press Limited versus University Press Limited case, because the quantum of originality, of course, there is effort, intellectual labor, etc. behind, but that is not that very that very big, large. Though it is minimal, it should be there. That's what the copyright law says. And to better understand, we consider this case. Now, I don't want to dwell on that anymore. And we had these cases also for our discussion. We discussed a database related to the case, though the position in India is a bit different from that of US and other jurisdictions. And we considered originality in the case of computer program. And we consider a very interesting question. Vidya ma'am, do you remember this case? If you don't mind. I know you are a senior person.
Sir, I don't. Sorry, sir, I don't remember it. I just
Yeah.
that matter I remember, but name I forgot, sir. Sorry.
The case is Becker versus Sheldon. It's also a very old American case, American Supreme Court case, wherein it is said that if there is a merger of idea and expression, which means if an idea can be expressed only in one way, or a reasonable expression of an idea is possible only in one way. So there is a merger of what you call idea expression. And if that be the case, then there is no copyright protection available to that. The simple reason is this: copyright law doesn't protect ideas. If you're protecting this particular idea, which is the only expression, then it's as good as saying that it is the protection of ideas as such, which is against the basic tenets of copyright law. So, ma'am, that was the decision of that particular case, which we can definitely carry, with us. So ultimately, what we would say, what we can conclude is this: copyright law protects original expressions of ideas after fixation. The idea of fixation is this: your expression of a poem, for example, poem about anything, poem about hills, poem about on a snow, poem about anything. It could be about rain, anything. Unless it's fixed in some form, digital or otherwise, analog form, you don't have a protection for that. That is what we call as a fixation. So your expression should be fixed. The very requirement is for the purpose that if there is mainly for the purpose that if there is a dispute in the future about the authorship, the ownership, which is valuable, then the courts, what courts do is it will go for a comparison of the first work and the second work. For a proper comparison, you should have something in a permanent form, in a retrievable form. So what you do is, what courts do is, courts, what they do is they'll just have the first work. If you are the first owner, first author, and you come out with you are a plaintiff and you come out with a case that the second author has copied your work. Then what the court does is, court will compare the first one with the second. And if it is substantially similar, then you have the second person has committed a copyright infringement. So the idea of substantive infringement is also to be discussed, which we are going to do later. Now we have reached a place where we may have to have an understanding about author and owner. The idea is this: author is the first owner. That's a declaration of copyright law under section 17 of copyright law. Author is the first owner. I repeated it, or I went for the statement again because I want all of you to remember it. You might already know that, but there are very many instances where owner may not be the author. So the general declaration of section 17 has very many exceptions which we should not keep blind of. We should be aware of, we should be looking at those exceptions. Which are the exceptional cases in which author may not be the author. We may not go very deep into that because our time may not allow us, but still we need to have some basic understanding about it. Let's do that. So the first declaration you can see on the screen. I invite your attention to the screen as well. Author is the first owner of the copyright, section 17. But as I said, there are exceptions. Your discussion of exceptions are important. The first exception is in the case of employed author. Like for example, Gayatri has just joined. I'm taking Gayatri as an example for that. I hope you don't mind Gayatri. So Gayatri is an employed author. She's a journalist, for example. So what happens is, let's read this. If the author is employed under a contract of service, you're all teachers and postgraduates. So I don't want to discuss what is contract of service and contract for service. Those differences you might already know, especially under Workmen Compensation Act 1923, which is retitled as Employees Compensation. Okay, so contract of service, or you're an apprentice in a newspaper, magazine, or other periodic. So that's the situation. You are an employed author. Then what happens? Let us read on. Let's go to the next sentence, which says, if employed author creates a work, Gayatri creates a work during the course of her employment, then what happens? The employer will be the first owner of copyright for the purpose of publication in newspaper, periodical, or other magazine. which means that if a journalist creates something during the course of his or her employment, then for the purpose of publication in this periodical, automatically copyright will allow, or copyright goes to the owner of copyright. Or for example, if it is Times, for example, or the Hindu, for example, or Manorama, for example, and if you're employed there, and if you're making an article, a feature, for the purpose of publication, during the course of employment, you are under a contract of service or you are an apprentice. So for the purpose of publication in that periodical, you won't be the owner. The owner will be the newspaper or magazine or whatever it is. But importantly, very importantly, I invite your attention to the short sentence there. For other matters, author will be the owner. Is that clear to everyone? Can I ask like that? Is that clear?
Yes, sir.
Yeah. Can I move on? I hope I can. So let's think about the second category of exception where owner may not be the author. What it says is, in the case of photographs, in photograph, painting, portrait, engraving, or cinematograph film is made by an author for valuable consideration, which we can call as commissioned authors. Commissioned authors, valuable consideration. The person who engaged the author will be the owner of the copyright. A simple example of from our own locality, from our own experience could be our marriage. Or maybe many of you might not have been married, but still, hopefully that will happen. Yeah, that is it. So what happens is you are engaging a videographer and a photographer, and you are paying him. So he's taking video. We say he's videography, and he's making an album as well of still photographs. So as you have paid you have paid the person, or rather that person can be called as commission author. So if photograph, painting, or portrait, engraving, or cinematography is made by an author for valuable consideration, the person who engaged the author will be the owner of copyright. Or got a very an amplified example of Lucifer film, which is a Malayalam hit film. Anthony Perumbavoor, who is the producer, has paid paid for that, paid the director and everything. He will be the one. Now again, now you have a film called Marakar and Arabic. A film I came across that in WhatsApp. So it is said that though the producer of the film is Anthony Perumbavoor, somebody has paid for that. I think Liberty Bashir has already paid. If Liberty Bashir has paid for that, Liberty Bashir will be the owner of it. No, those are some of the. I don't know whether it has in fact has happened, but those could be the instances which would make us understand. And next instance in which the author may not be the owner, could be the person delivering speech on behalf of another. So after 2012 amendment, there is a major amendment to copyright law in year 2012. I have got a copy of that also, but I don't think we need to go through the section as it is. I'll just explain it. What it says is, if a person is delivering a speech on behalf of another, the person delivering a speech on behalf of another, the speech is prepared by Mr. A, and Miss B is delivering that on behalf of Mr. B. Then Miss B will be the person who will be entitled for that. Ownership will vest with Miss B. It is immaterial whether where it is presented and what occasion it is presented. All those matters, all those things won't matter. It's also declared under section 17 as changed as it is now, as it stands now after 2012 amendment. And there are certain other category of works as well, like government work, which means that a commission, for example, a commission report prepared by Kasturi Rangan on behalf of Central Government of India. though the author is Kasturi and Rangan and his team, perhaps joint authorship, the ownership of that, the copyright shall vest with the government. Likewise, in the case of works of public undertakings, somebody is creating something, an employee is creating something for a public undertaking, then there is no question of payment of remuneration or contract of service, etc. Those requirements have not been laid out here. That's notable as well. So in the case of government work, in the case of work of public undertakings, etc., even though there is no contract of service, even though there is no payment, there is no requirements as per law. So even though it is not there, even then the work and the copyright for that, though the authorship is with the person who is creating it, the ownership or the copyright shall rest with the person, the undertaking or the government work or the international organization. Same is the case with the international organization. Now I have mentioned two cases. One is a case from Kerala itself. It's a judgment of Kerala High Court, but it's very popular. You might know that. You might recognize. You might definitely recognize those two little ones, Tom, Bobbin and Molly. Very popular. What do you call cartoons? But the problem is, it's not a good case to understand copyright law, especially Section 70, because at least to my understanding and also to the understanding of many people who are experts in this area, that judgment doesn't go well with the basic principles of copyright law. So we are not going to discuss it. And there is another case which I mentioned. I thought I'll just mention and go forward. It is IPRS versus Eastern India Motion Pictures Association. Please do understand that it is a case in which it's not good law. Now, even if you come across this case, please do understand that is per curiam now, because law has changed in 2012. This is a case in which it is stated that if a literary work, for example, lyrics written by, for example, Javed Akhtar or O.N.V. Kurup or anyone, Kaidapram Damodaran Nambudiri, was written it, and if it is incorporated in a film, automatically the whole right will go to the cinematograph film owner, that is the producer. That was a judgment in the case IPRS versus Eastern India Motion Pictures Association. But that position stands changed, and this case is per curiam now. That position has changed after 2012 amendment, and it states that at the end, as the last sentence, which is added to Section 17, which says that incorporation of these work, the musical work or the literary work or any of the dramatic work, even though it is incorporated in a cinematograph film, the cinematograph film owner will have right as far as its publication and its exhibition is concerned. But the basic right available with the literary work owner or the dramatic work owner or the musical work owner will remain as it is. It will not get affected. So it bettered the rights of literary work and literary work, dramatic work, and musical work, or those artistic work owners vis-a-vis the owner of cinematograph film. So that way it is notable, and this case is not a good law as it stands now. Now, we are moving on. I think so far so good. You're all we are all together in the same boat, moving together. Is a slide still visible? Somebody?
Yes.
Okay, fine. Now, you are here, Pradeep. It's nice to see you. Yeah, we both of us are in the same material. It appears. Okay, you have a better seat, but okay. Coming back to the formalities. Now, the question here is whether we need to complete any formalities to have your right. This could be better understood in comparison with some other copyright, some other intellectual property. We'll take the example of a patent, which is little, not little, largely largely criticized, and it's very popular. Perhaps it's a little unpopular as well. That way, but it's known. So what happens is, in the case of patent, what you protect is an invention. What patent law protects is an invention. But if you just invent, if Mr. Pradeep invents something, and if he just keeps quiet, which means that he's not going for any formality like registration with the concerned office, he's not having any right. He can use it, I can use it, any Tom, Dick, and Harry can use it, which means anybody can use it. So what we can see is in the case of patents, there is a precondition of registration. You are not a right holder, Mr. Pradeep, with your permission, unless you go for a registration. So the protection is not automatic. There is a precondition of registration. But in comparison, what you can see here is in the case of copyright, protection is automatic. What does it tell us now? It says that in the case of copyright, the moment of the last full stop of your poem, the moment you complete creation of your work, whatever it be, let it be cinematograph film, let it be musical work, anything, you are a copyright owner. You are a copyright author, you are a copyright author. So which means that there is no formality. Registration is not compulsory. It's as in the case of, you can have another comparison from the area of company law and partnership. In the case of company, to come into existence, registration is compulsory. Unless you register, there is no company. But in the case of partnership, as per Partnership Act 1932, as you might already know, registration is not compulsory, it's optional. But of course, there are very many benefits which will really make you entice towards registration. But even without registration, a partnership can exist and come into existence. So is the case with copyright. So if you don't register also, there is a copyright. Registration is optional, and if you register, there are advantages. So copyright exists in the work from the very moment of completion. That's what we may have to understand and keep in mind. So if that is clear, let's move further. Now we are going to understand the rights of owner of copyrights. So every intellectual property has a pattern. So is the case with the copyright law also. The pattern is this: the law concern, be it copyright, be it trademark, be it patent, whatever it be. First of all, they will identify the subject matter of that particular act. Here, in the case of copyright, we have understood the subject matter. You have literary work, artistic work, and things like that. In the case of patents, they identify invention. In the case of trademark, they identify a trademark. So in the case of any other design, they identify that design and related thing. Then they will speak about the authorship and the ownership. So we have completed both these in the case of copyright. We know the subject matters. We know the copyright authorship and ownership. We know that. Then the pattern of intellectual property law is this. Then it would speak about the rights. Then it will speak about the transfer of rights. Then other formalities like infringement, remedies, etc. This is the usual pattern. So is the case with copyright. So we have reached the stage of understanding the rights. So as you can see on this slide, again, I invite you back to the slides. In the case of copyright, you have two kinds of rights, I can say. Two kinds of rights. What are those? The first one is you have economic rights. The second one is moral rights. The terminology, if you take in, applying your mind, the terminologies itself will tell us what kind of rights they are. I put some explanation there, which you can easily read and understand, which you might already know, but still let us understand it better. Economic rights allow the owner financial reward from the use of work. For example, a literary work. Yeah, any questions? Any questions, please? Anything? Any intervention? No, I can continue. Okay. So what happens is in the case of economic rights, you're an author. You have written a book. What you do is you make as many copies as possible, maybe 10,000 first edition. and you sell it and you make money out of it. You have a music, you allow others to play it, or you make a CD, or you make it available through your website for a royalty. You make money out of it. So this is concerned about the financial well-being of the copyright owner. Rights are nothing but interest of the owner, and financial interest of the owner of copyright is taken care of by the economic rights. So it goes without saying, but that's it. And second category of rights available to a copyright author, I would say, I would just amend what I've written there, but that's for a purpose which I'll explain. So in the case of moral rights, what happens is it's concerned about the personal link between the author and the work. So for example, M.T. Vasudevan Nair, a celebrated author in Malayalam. Arundhati Roy, another good example. Shashi Tharoor, you got umpteen number of examples. And see, usually they don't publish themselves. What they do is they just give the rights, transfer the rights to the publisher, TC Books, Penguin, or any other publisher. So once Penguin pays to the author, they get the copyright. They become the owner of copyright. But nevertheless, even after transfer of economic rights, or after the transfer of copyright or the economic rights, there are certain rights which are still with the author. Those are rights which will show the personal link between the author and the work. Because as far as the author is concerned, it's as good as a child. It's a brainchild. So to have that right being recognized even further. For example, even after transfer of copyright or economic rights, the author has the right to be recognized as the author. Arundhati Roy's name should remain even after it is being transferred to Penguin. Penguin can publish it only recognizing Arundhati Roy as the author. If they don't do it, Arundhati Roy can't stop it, because that doesn't show the personal link, the moral right, the special right available to Arundhati Roy as an author with God of Small Things. And another right is that of integrity. Perhaps another author might present the same idea, same novel in a different fashion. Perhaps that is better also. It could be better. But there is something known as integrity of work. Author wanted its child, the brainchild, to be in certain fashion. Whether it is good or bad, that's the way he or she wanted it to be. So that will remain as it is. Just because the economic right of publication is transferred to a publisher, he or she or they do not have the right to make even a single comma from that. So the integrity of the work also should be protected as it is. So those are known as moral rights. Let's go. I think I've given you the basic understanding of that. Let's go further for the discussion. Again, please have a look at this with some with some money economic rights. Economic rights are discussed under section 14. It's perhaps one of the lengthiest sections in copyright law, and it speaks about different kinds of rights in the case of different kinds of works. For example, it lists out rights in the case of literary artistic work. It gives certain special rights in the case of artistic work. It speaks about different rights in the case of different. It makes a list with regard to each and every subject matter. And if you go through all those, which we are not doing it, what we can see is there are almost the common rights, or the main rights, I could say, or common rights available to almost all the subject matter owners could be listed out like this. The rights, economic rights, recognized for a copyright owner under section 14 of copyright law are, as you can see, reproduction right, right to reproduction, right to distribution, right to public performance, right to communication to public, translation right, rental right, adaptation right, and right to importation, and of course, right to exhibitions. These are the rights you can you find you come across if you go through section 14 meticulously. What we are going to do now is to make sense of these rights. Let's do that. Yeah, right to reproduction. No, we may not go for discussion of cases in each and every area. We'll just make an understanding, and wherever it is required, we'll do it. Right to reproduction. Reproduce is to make copy. Rather, this is the right which gives copyright its name. Right to make copies. It could be in various forms. The examples are put there. You can think of various examples also. In future, there are going to be different in other different forms of reproduction also. It could be printed publication of a book or a pamphlet, or it could be recording in cassettes, olden days, bygone days, good or bad, CDs, DVDs, or making it available in in digital forms, or storing in computer memories. So these are all different forms of reproduction. Reproduction would mean you are making copies of it, but you will make copies of it and sell it only for a price. Usually, if you believe in, if you are concerned about, if you are a capitalist, if you are concerned about money, then you would pay for, you will definitely take money for it. You can be a philanthropist as well, but usually people are not like that. So this is the various forms of doing it, CDs, etc. Now, as far as reproduction is concerned, that goes well to make us understand. But I may have to have this particular case, which gives a special kind of reproduction right in the case of artistic work. If you read section 14 carefully, in the case of artistic work, reproduction right is couched in it is formulated. The section is formulated in a bit notable, remarkable way. It says that reproduction right includes, please note, reproduction right includes conversion or depiction of two-dimensional artistic work into three-dimensional artistic work, and the reverse as well. I'll have to repeat it. I feel, because in the case of artistic work, reproduction right means it is not just reproduction of artistic work. Take for example a photograph, or for example a picture, a drawing. Making copies of that will definitely be, making copies of a picture is definitely, goes without saying, doesn't require so much of a common sense to understand. So it is definitely a reproduction. So without the permission of the copyright owner, without the permission of the copyright author, if you're doing it, you're violating copyright. So that is without his permission, without paying him. No, you can't do that. But this is a situation where a two-dimensional picture, called a painting, and based on that you are making a statue. You are making a statue, or it could be reverse of that. You have you have a statue there. What you're doing is you're just making a copy of, or making a copy of that statue in two-dimensional. Statue is in three-dimensional, goes without saying. So conversion or depiction, that's the word used there. we go to section 14, depiction from 2-dimensional to 3-dimensional, a picture to a statue, and a statue to a picture. And this will be more applicable in the case of commercial use. I'm bringing to your attention as such an instance through this case. This case is important. You don't have much of these kinds of cases, not only in India but also in other jurisdictions. This is one of the important cases here. Now have a look at for the purpose of understanding that. So the case is Escort Construction Equipment Limited versus Action Construction Equipment Limited. Better to remember the name. So what happens is there is an industrial drawing. I don't know whether you are aware. I was not. I came to know about it when I read this case. Usually before an industrial product is manufactured, they will have industrial drawings about it. Each and every part, every dimension, all those will be drawn. Here in this particular case, there was industrial drawing of a mobile crane. Crane, you know it, right? Caterpillar. When you call it crane, which actually means cook in Malayalam. So what happens is, perhaps it looks like that. Industrial drawing of pick and carry hydraulic mobile crane. You can see the basic facts in the screen on the screen. So the first company had that. The plaintiff company had that. What the second company, defendant company, did was they did not copy these pictures as it is, but with the help of those pictures, those industrial drawings which are good enough to make you understand what to make and how to make and how to complete it. So what the second company did is, second company depict or made the product out of these industrial drawings, and the reverse is also possible. So in this case, what has happened? So this first company came out with the plaintiff company came out with the case. It says that they have violated our copy, and the bond of contention for the defendant was that we did not copy the drawing. We did not make many copies and sell it. We did not commercially use it. But relying on the particular section which I'm referring to under section 14, it said that in the case of reproduction right, in respect of the subject matter of artistic work, it is depiction also, which means that as they have made the product out of industrial drawing, they have violated reproduction right. I'm emphasizing on this because this may not come to us as a matter of common sense. This is something which we may not contemplate about. I have to tell you, and I may have to read and understand. So what happened is a defendant was restrained. So this is what I wanted you to remember additionally. Otherwise, reproduction right is making copies and making use of that and making money on it. It's an economic right and a very important right. It's a fundamental right as far as copyright is concerned. Now let's move to understand further. I've got an English case here from England. Hawks versus Paramount Film Services. Hawks versus Paramount Film Services. That's the case. So here the facts are already on the screen. I again request you to read this. The situation is this: music for 1 minute was copied from a work which was of several minutes duration. The best example, the best comparison I can draw in Indian context is that of Airtel. You recognize Airtel music, right? Mr. Pradeep, do you or anybody? Give me an S, at least in the chat box. Do you recognize Airtel music? Anyone?
Yes, sir.
Just to ensure that you people are there. Yeah. You recognize, right? And for your information, that particular no, audio clip, which we recognize as Airtel music, maybe 5 seconds or so, 2 to 3 seconds or 5 seconds at the most. This is taken from a musical composition which A.R. Rahman made, of course, for payment for Airtel. And it's lasts for almost 120 seconds, to my understanding, around. I'm not very sure, but it's around 120, 180 seconds. So from 180 seconds, 3 or 4 seconds are being, I see, take for example, think that I am a commercial user, another company. I am using this 3 or 4 seconds music, which we identify as Airtel music, for the commercial advertisement of my company. I am the defender. So how much quantity should be taken to constitute an infringement? That's a question here. This is related to reproduction. So if I reproduce from a book which lasts 1,000 pages, I just copy one page or one paragraph. Is that a violation of copyright? Is that violation of reproduction right?
Yes.
Or is it required? Yeah, please.
Because it is taken from a work, no, sir. Reproduced means same thing is once again used.
Yeah, that definitely, ma'am. That could be our sense. But is it necessary for us to copy the entire work? That could be the question on the one side of the Vibgyor spectrum. Or taking even a sentence or even a word from a book, will that amount to copyright violation? So in order to constitute copyright violation or to understand the scope of reproduction right, that's what we are trying to do. Either way, how much copying should happen? So what's the scope of reproduction right? So this case is brought in for the purpose of understanding that. So here in this case, there was a musical, perhaps album or whatever it is in West, it is pop music, perhaps. The defendant used the music of the plaintiff, which lasted for several minutes. It took just a few seconds. So a good analogy I gave, a comparison I gave in the context. From 180 seconds, you are taking 3 seconds or 4 seconds of Airtel music. Will that constitute a violation of reproduction right? Or rather, is that the scope of reproduction, right of reproduction? And in this particular case, it is said that considering the quality, that's the reason why I've just boldened that. I wanted you to apply your attention to it. Considering the quality, importance of the part taken, it is substantial copying. There are two things I would like you to remember. I want you to remember this. Remember two things. In order to understand the scope of reproduction right, we need to understand substantial copying. In the case of substantial copying, welcome Vidit sir. In the case of substantial copying, what happens is the quantity you have taken, the part you have taken should be substantial in comparison with the whole of the work. I repeat, in comparison to the whole of the work, the part defendant has copied should be substantial. Then the next question is how to decide the substantiality. In order to decide substantiality, what criteria should we have? Or what are the criteria courts have devised? That's what we are trying to understand. This is very practical oriented. We need to understand this. Now, it could be either quantity, a test of quantity, or it could be a test of quality, or a test of both, or a test of none. So here in this case, as we said, from 180 seconds, 3 seconds are copied. Is that substantial? What does your sense tells you? Out of 180 seconds, 3 seconds. From a book of 1,000 pages, 1 paragraph or 1 page. Does that constitute a substantial part? Because then only there is copyright violation. The scope of reproduction right is based on the concept of substantiality. The scope and whatever you call it, the volume, the understanding. So to answer this, I brought this case. Here in this case, what the court has said is, considering the quality and importance of significance of the part taken, it is substantial copying. Though out of 180 seconds, 3 seconds are taken, or from a 1,000-page book, 1 page is taken. Even then, if it is of higher quality, because as far as Airtel Music is concerned, those 3 seconds, which all of us are familiar, though quantity is less, its quality and significance, perhaps because of the use of it, the way in which they are using it, just become a significant part. So quality-wise, it's important. So 3 seconds out of 180 seconds could constitute substantial copying. If it is substantial copying, then it is copyright violation. So we need to have a better understanding. A better sentence will do, I think. Better understanding of substantial copying. Whether a substantial part of the copyright material has been copied depends not merely on the physical amount of reproduction, but on the substantial significance of that which is taken. Which means, in simple words, it is not only the quantity that matters, even the quality matters. So it's a matter of quantity as well as quality. It is looking at this quantity as well as the quality. You need to decide substantiality question in order to understand the scope of reproduction right, and also to then answer the question of infringement of copyright. Would that be all right, ma'am Vidya?
Yes, sir, very much.
Thank you so much. I am encouraged. There are other cases also in the same line. I don't want to spend much more time on that. This is a case Ladbroke versus William Hill, wherein there was some 20-25 pages what do you call pamphlet regarding football fixtures and things like that. And they also had a game which made that popular, because you see that you get to read this in get these kinds of games. They make you play games and win prizes. So which if you once you may have to fill in certain things in a newspaper, you may have to fill in certain things in a pamphlet, and you may have to send it to the organizers, which will make the game what you call popular also. So all these ideas relating to this was incorporated in short form. The distilled essence, I would say, the distilled essence of the total idea was incorporated in a particular page, in 1 page or 25. The pamphlet lasted for 25. The total idea about this game, all these fixtures, everything was incorporated in 1 page. So what the defendant did was, he or she, I don't know, copied this word 1 page only. And they said, we just took 1 page. It's not a substantial copying, so it won't result in substantial copying, and so it won't consequently can be considered as a violation of reproduction right of copyright. So that's a case of Ladbroke football versus William Hill. Now I don't think I would I may have to explain it further, because you will have to look at the quantity as well as quality. And if you may have to look at the quality as well. This was held as a violation of copyright. This is very much within the scope of right of reproduction. I think we can move on. Now, this is something obvious, but I should state the obvious. The case is Star India versus Leo Burnett India Private Limited. Two parties, obviously two parties, and only there is a case, usually. Now what it says is, from the very sentence, you might perceive what the idea is. If subsequent film is shot separately, even if it resembles the earlier, it is not a copy. We are all aware of Priyadarsan, right? Is there any candidate, any person attending who has not watched a film of Priyadarsan, Pride of Kerala, and you all of us have watched films of Priyadarsan, and many people say no. Okay, I'm sorry. Priyadarsan has directed not less than 20 films also. He has directed films in Telugu, Tamil, and of course in Malayalam also. If you, I don't know, I'm not very sure, but then yeah, even you might have heard about at least Priyadarsan. And for most of the participants, it could be a good example as well. So many of the films of Priyadarsan are inspired. That's what they say. Inspired from Korean films, Hindi films, English films, etc. Many of his films, or most of his films, the storyline may be the same. If you have watched that film in another language, which was made earlier, you will definitely feel that this is inspired within double inverted commas by the original. But what law says is, what courts have interpreted is, if the subsequent film, even let it be Priyadarsan film or any other film, if the subsequent film is shot separately, which means that you have written a screenplay of yours, you organized everything, you have a cast, you have a crew, you have a cameraman, you have a director, you have your own location. You're taking all this effort, and you are shooting a film of your own, though the storyline is the same. Even if it resembles the earlier, it is not a copy. It is not a violation of copyright. It is not violation of reproduction right. The basic reason for this is copyright law does not protect expression. Though the basic idea, the storyline may be the same, but the first film was shot with a very different setup. It has its own director, but of course, there's a producer. It has a cast, it has a crew, it has got all the people. And it is shot in a particular location. They took efforts for that. And here there is a second film which has the same storyline, but different director, different producer, different cast, different crew, different cameraman, different location. So as the expression is different, please remember, again, copyright law protects only expressions, not original ideas, not ideas as such. So as the expression will be different in a different fashion, different manner, the subsequent film, if shot separately, even if it resembles the earlier, is not a copy. It is not a copyright violation. That's what it says. Now I think that's all about that's all about reproduction right. There is a line, there is a right which can go along with a copy reproduction right. That is a distribution right. The right to distribution can be understood as the right to distribute copies of the work made through reproduction right. If you apply your mind commonsensically, you might wonder why this right. If a person has a right to reproduction, why can't what's the need of this particular right? Is there a need for a right which particularly says that you can distribute it? The answer is yes. If you go to go to the history of copyright, there were instances where A person made copies, but he wasn't allowed to sell it, or not allowed to sell it in a particular jurisdiction, in a particular market. So, in the case of literary work, if you take that as an example, this right is available in the case of literary work, musical work, etc. So it is not only right to make a reproduction, right to make copies of it, but also the right to distribute it. It is not distribution for free. Distribute in the sense you can use it in the market, you can exhibit in the market, and you can, of course, you can have your money, you can have your currency with you, you can have your revenue generated from that. So distribution right, that means the right to sell to public copies of the work. So if you've understood reproduction right, as we have already understood, you have a right to distribute it also. You have a right to economically exploit that, to put it in the market and recoup your investment plus a reasonable profit. That is the sense of distribution right. Now to the moderator or the organizer, I have a question. Can I move on a little bit, or should I stop here? Right? It's 11 o'clock. I'm sure about it. What should I do? Or can I stop, or can I continue the next class? The organizer from LJRF. I request an answer.
Thank you, sir.
Continue. Sir, continue ചെയ്യാൻ തോന്നുന്നു for some time.
For 10 minutes or so?
Yeah, that's fine, sir. Continue ചെയ്യാം.
So, Jinsia, please reserve your gratitude. I will definitely have it.
Okay, sir.
Okay. No, don't mind. Now the second right is public performance right. Right to public performance, which has got another incarnation, which we can call as right to communication. Public performance right and right to communication. It is like this. Public performance and right to communication to public are different. Public performance, for example, public performance is the situation where you may have to go back to Shakespearean period. I can have an example of that period. Now I got to read. I read a book on Shakespeare a few years back, wherein it is stated that in 1624, in that period when Shakespeare was 10 to 15 minutes. Thank you. Yeah. So during that period, UK had theaters, drama theaters, which can contain, which had seats of around 5,000. I know it's from and the author of the book was an archaeologist as well. He was looking Shakespeare from a different perspective. So what happens is, if Shakespeare or the people of Shakespeare, if they are just performing that in front of those audience, it is public performance. They will have to pay for that. Shakespeare and his team is making money out of it. The same thing can happen in the form of mimics parade or whatever cinematic dance in today's world. Or you have very many other programs which are conducted in auditoriums and in other places, and you'll have to pay for that. That is public performance. You are performing in front of the public. You have the exclusive right to reproduce it. You will have the exclusive right to publicly perform that. If somebody else is doing that without your permission, you can stop it. And when you make public performance, you have got the sole authority to decide whether you should be paying it, you should be performing that in front of the paid audience or otherwise, which means it makes available to you the right to make money out, because it is an economic right. So example of this right would be performing music in a concert or a play on stage, or it could be in an orchestra, anything of that sort. A right which is similar to that of public performance right, but a different kind of communication is right to communication to public. It could be in different forms. It could be radio, mass communication in one word. It could be terrestrial broadcasting. It could be satellite broadcasting. It could be cable broadcasting. It could be digital broadcasting, webcasting, anything, or going live in Facebook and Instagram, all those. So both these rights are also very important, basic as far as an author is concerned and honor is concerned, because it gives the person a lot of what you call a lot of opportunity to make money. This is one of the basic ways in which the copyright owners exploit, especially when it comes to films and music and things like that. Now, so means making any work available for being seen or heard or otherwise enjoyed. It could be performing or making it available. Perhaps it could be in this particular form. It's available. Music is available in a particular website, so it is made available there. You can reach that site. You can make money through Google Pay or any other mode, or your card, or whatever be the mode. Then you can access it. You can enjoy the music. Same is the case with our what do you call this Amazon Prime. So they are making that available. You can access it. Of course, you will have to pay for that. Maybe even if it is a small amount, you'll have to pay for that. And Amazon is making money from that. That could be one of the examples. So it could be you are performing it, or you are making that available in a particular form. So it could be radio, it could be TV, it could be satellite, it could be terrestrial, it could be casting, or it could be anything of that sort, which means that you have got the right to commercially exploit in this fashion. And if somebody else is exploiting in this fashion without your permission, you can stop that person. That's the situation. So means making any work available for being seen, heard, or otherwise enjoyed by public directly or by means of display or diffusion. It is immaterial whether the public actually sees, hears, or otherwise enjoys the work. Many of the works may not be seen by anybody. Krishi Darshan in Doordarshan could be a good example for this. So radio, TV, cable, or satellite. Now we'll just complete it in a few minutes. You have a case here. The case name is put at the center. Garware plastic and polyester versus Telelink. Here, the situation is this. I think I had shared this case with my students in GLCP also, but this is an important case to make us understand what public is. So what happened was a local cable TV owner, had a CD or something, and he just what a cable casted. I don't know whether that terminology can be used, but I use it, which will convey. He cable casted maybe to 250 subscribers in his area to see a new film. He just had a copy from somewhere. Perhaps that's a paid copy also. I don't know, but he had a copy, and he just cable casted this to 250 members of his locality, his subscribers, from whom every month he'll collect a fees. Now what happens is, there was a case. Obviously, the copyright owner was not happy. The copyright owner or the film producer was not happy about it. Let's again go back to any example of Lucifer or any other film. So if a new film is shown like this, definitely it affects the revenue making power and capacity and the right of the copyright owner, the producer, the company. So they came out with a case. And very importantly, the argument on the side of the defendant is notable, perhaps interesting also. The argument is this: the people watch this film, the newly released film, sitting in their private rooms, perhaps in their drawing room, perhaps in the their bedroom. Now you have TV even in your bathroom, I suppose. So so they all these are private places. So the argument on the other side is it was a technical argument, but they had this argument. And I just wanted you to apply your mind to this as well. The idea is this, they said this is not communication to the public, because none of these people, none of the 250 people and their family were sitting at a public place and watching the film. So this is not right to communication to public. It is not part of right to communication to public. As they are not part of the public, it is not violation of their right. So there is no copyright violation. That was the bone of contention. That was the argument. How do you look at this? How do you view this? Is that sensible to you? Isn't it sensible? How do you react to this? I don't want, you may not answer it, but I want you to think about this. But it really, gives us no food for thought. Now, I don't want to spend much time on this, but let's wind this up. The court has said public is to be understood in the context of the law. The purpose of copyright law is to protect honor of copyright and to make available to him the economic reward for his effort. Now, public is to be understood from the point of view of the honor. As far as the film honor is concerned, the producer is concerned, from the point of view of the honor of the film, the producer, whether a person who is sitting in his bedroom and watching the film, is she or he part of public? That is how you need to understand this. So I have put it at the end in a phrase in bold. The court has said that public is to be understood in the context of copyright law, and public should be understood as honest public. Even if you are at your private place, from the point of view of the honor, the producer of the film, if you are part of the public, then definitely you are part of honest public. So this is right to communication to public. So it's part of my right. And if somebody else is doing it, then definitely it is a copyright violation. This is more added relevance, especially in today's world, where you have releasing in OTT, Amazon Prime, Netflix and things like that. In all these cases, you watch the film or you watch the program online sitting at your private room. So, but from the point of view of the honor, you are part of the public. So the right to communication to public is to be understood in that fashion. And we'll go to those rights and other things for discussion in next class. Thank you for joining and listening. If you have any doubt to raise, you have time for that. Otherwise, we'll break. Thank you.
Thank you, sir. Thank you.
Thank you so
If
much.
anybody has any doubt, please put it across. Sir, I think we can.
With your permission, I'll leave. Thank you so much.
Okay. Thank you. Thank you. Thank you.
Thank you, everyone.
Thank you, sir.